All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause, and then we will talk about release conditions. Today's not your trial date, and so I encourage you to speak with your attorney before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. For those of you represented by the Public Defender's Office, in the courtroom, I do have one of their attorneys, Mr. Brian Reedy. Over at the main jail is Mr. Hector Romero. For those of you who are at the other facilities, these attorneys are available to you by phone. So if you have any questions, please make sure you ask. Those of you who are represented by a private attorney, your attorney will come to the courtroom. If your attorney is not here, then you can let me know, and we can see if we can reach out to your attorney. However, I am quick to tell you, please don't tell me you have private counsel unless you or your family have indeed, in fact, retained that attorney for this arrest. Because an attorney represented you in the past, or they may be representing you on a pending matter, does not automatically mean that they are representing you here today. Also, in the courtroom with me, I have attorneys from the State Attorney's Office, Mr. Eric Linder. I also have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here. They are able to provide additional information if needed. Some of you this morning, those of you charged with misdemeanor cases or municipal ordinance matters, may be able to resolve your case at first appearance. That is also dependent on what's going on with you personally. For those of you who are facing felony charges, those of you who have violation of probation matters where the judge already signed the warrant and said it's a no bond hold, those cannot be changed here at first appearance. You will have to appear before your division judge to address those matters. After today, if your case has not yet been assigned to a specific division judge, it will be. And then moving forward, any pretrial motions that you may have, or if you end up going to trial, all those matters will be heard by your division judge. So today's not your trial date. It's not an adversarial hearing. And so please speak with your attorney before saying anything on the record, all right? There are a number of persons that the jail has asked to call out of turn. I've pulled those files, but Mr. Romero, or whoever is at the main jail, thank you.
Yes, sir, sorry about that.
All right, no, that's okay. So, Mr. Romero, on page, I'll just tell you some persons who've signed in for further down on the docket. So on page 24, there's Jonathan Mejia. When he's available, if you will let me know.
Yes, he's here, and I'm gonna speak to him right now.
On page 26, there is Gene Joseph. He has private counsel. When he's available, if you'll let me know.
He's here, actually. He's here already in the courtroom,
Bond,
ready
Your
to go.
Honor, if
He
it's
what?
acceptable. If the bond is acceptable to Your Honor, we have an agreed amount.
You have an
Mr.
agreed
Joseph.
amount? All
Yes,
right,
we do.
so then we can address Gene
Thank you very
Joseph.
much.
Good morning, Mr. Milne.
Good morning, Your Honor, how are you?
So Gene Joseph is before the court this morning on one charge of burglary, unoccupied conveyance unarmed. Number 2 is grand theft. 3 and 4 are violation of probations with no bond holds. You have an agreed amount as to the bond on one?
Yes, we do, Your
How
Honor.
much is it?
Mr. Linder, it was $2,500 each count, correct?
Actually, no. I thought
One.
2,500 on the burn.
$2,500 on the
just-
burglary, $1,000 on the grand theft.
All right, so I will accept that bond. He does have a status hearing on the 23rd.
Correct.
All right, so $2,500 on one, 1,000 on two.
And we go to Judge Merrigan on Monday. Thank you very much, Your
You're
Honor.
welcome.
Okay, thank you.
All right, for those of the jail has asked to call out of turn, Demetrius St. Louis on page 10.
He's approaching, Judge. Come on up, sir.
All right,
Yes.
Mr. St. Louis is before the court this morning. This is a change of charge, or it's an upgrade?
It was an unfiled to a felony, Your Honor. I reviewed Odyssey. Judge McHugh, who I have no reason to believe wasn't advised of his criminal history. Set the bond at 1,000, order no victim contact. I'm fine with the court setting that bond.
All right, so we'll leave those conditions in place at his division, the previous division judge.
The only request I would make, Your Honor, is that a new no contact order be prepared since the other one was
All
assigned,
right.
was connected to the MM
The minute,
case.
okay, so, sir, no victim contact remains in place. No contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
Okay. All right, then, next, Daniel Ross on page
Mr. Ross is
13.
approaching, Judge. It's your name. Come on up, Mr. Ross.
Mr. Ross is before the court this morning. Charge 1 is DUI, alcohol, or drugs. Number 2 is DUI with damage to property or person. And number 3 is failure to use due care, which is a traffic infraction not for magistrate. I find probable cause for these charges.
Judge, I'm going to be asking if the court would consider releasing Mr. Ross on pretrial release. My understanding is he's been living in our community since 2012. He's 57 years old. He's self-employed whenever he can work. He does taxes. Unfortunately, right now, financially, he's going through a difficult time. He's basically in between. So in a way, he's homeless. I believe the last prior contact with the system was a minor offense. I believe a trespass. I'm going to be asking for the court to consider releasing him under supervision of pretrial.
Your Honor, I don't have I don't have an objection to pretrial with random testing. The only thing I would ask to be clarified, is he homeless or is he basically homeless? Is there an address for court notice to be sent to, or?
I have a P.O. box. He has a mailing address, but he's homeless.
Your Honor, I've just asked if you could advise Mr. Ross, there's no P.O. box number on any of the reports here, so the court notices are going to be going to an address in Aventura.
All right, so, Mr. Ross, first thing, I am going to release you on your own recognizance to pretrial supervision. Your attorney is going to give you the information for the pretrial office. Sir, today is Friday, and so there is a, Mr. Ross, you need to listen to me. Today's Friday, and there's a great possibility you will not get out in time to go to the pretrial office, and they are closed on the weekend. So Monday morning, by the latest, you have to report to the pretrial office on that information that has been given to you on that sheet. Do you understand that, sir?
Yeah, I can't get to the pretrial today.
I don't know.
You could, if you get out early enough, they close at 4. So if you can get there today, go there today. If not, the judge is giving you until Monday morning to report. Do you understand, sir?
Yeah.
Okay.
All right, and then you're gonna be subjected to random alcohol testing, and Mr. Ross, the next thing is that all this paperwork shows an Aventura address.
Yeah.
You
I
have,
believe that's his father's, and he can't get mail there. Judge.
okay,
I believe
so,
it is-
so we just want to be clear, because you said that you were homeless, but it is your responsibility to make sure that you check for your mail. So you can't say, because I'm homeless, I didn't get my notice, because either you check in with your attorney, or you check with the clerk's office, or you go wherever your mail is going. Do you understand that, sir?
Okay.
All right. All right, David Ponskowski.
He's approaching, Judge. Come on up, sir.
All right, Mr. Ponskowski is before the court. Charge 1 is battery on an officer. Number 2 is resisting officer without violence. Number 3 is failure to obey police or fire department. I find probable cause for these charges.
Josh Pados for the state. The state is asking for a $2,000 bond on count 1.
Okay.
Judge, did the state set $1,000?
2,000.
That's reasonable.
All right. So $2,000 bond for Mr. Ponskowski. Okay. Jorge Zapata on page 17.
Mr. Zapata, come on up, please.
All right, Mr. Zapata is before the court this morning. He has charges 1 and 2 are the same, robbery with a weapon. And I find probable cause. All right, does Mr. Zapata have any priors?
Yes, Judge. One moment. Your Honor, the state would like to advise the court that the defendant was actually arrested for burglary of a structure and grand theft, and he posted a $2,000 bond about a week ago from the date of this incident. These robberies occurred about 7 days after. The state has concerns for the safety of the community. Would be asking for a $50,000 bond on count 2. And if he does post, we would be asking for a GPS and no victim contact.
Other history does he have?
One moment. It looks like his other prior cases had been dropped, Your Honor.
All right, Mr. Romero?
Judge, Mr. Zapata is certainly not in a financial position to post a monetary bond, which the state is requesting. He's 28 years old, and right now he's unemployed. However, he did inform he's looking for work. He lives in North Lauderdale with his family. He doesn't know their financial resources, but as far as he doesn't own any sort of property, and he can't afford any sort of monetary bond, Judge.
In 2018, Mr. Zapata was arrested for a strong arm robbery. He was placed on pretrial in that matter. A warrant for his arrest for violating pretrial had to be prepared, and it was signed by his judge. The basis was he was scheduled for work between 6 a.m. and 9 p.m. After those hours, he failed to return to his approved residence, and at the time the warrant was signed, his whereabouts were unknown.
All right, he has a $5,000 bond on charge number 1. On number 2, I'm going to impose a $20,000 bond. If he posts his bond, he is going to be on a level 2 pretrial supervision. And in abundance of caution, no victim contact, okay? All right, Tyrone Torres.
He's approaching, Judge.
All right, Mr. Torres is before the court. Charge 1 is grand theft, first degree. Number 2 is exploitation of elderly, $100,000 or more. I find probable cause for these charges. And I'll hear from the parties.
Your Honor, I'm asking pretrial to check if he has any priors. I don't know if he does. That being said, I see no Broward priors, but that being said, I am going to be requesting, based on the amount stolen, and that he has been charged, this is past mere investigation, he has been charged with 2 first-degree felonies. I'm going to be requesting a $50,000 bond on each count. no victim contact.
Mr. Rivera?
Judge, Mr. Torres is not going to be able to afford a $100,000 bond. My understanding, first in speaking to Mr. Torres, he's looking forward to having his day in court and disputing these allegations. I believe the alleged date of incident when I believe he was arrested and advised by law enforcement, I believe the date of incident is somehow almost a year ago. Having said that, from what he advised me, he's had no sort of contact with this alleged victim. He has no problem adhering to that court order as far as no contact. Now, he's 48 years old. He's been living in our community for the past 8 years. He's self-employed. He's a songwriter. Right now, he told me things are going well. He gets paid about $2,500 to $3,000 every month. He's living in Pembroke Pines. He's been residing there for the past 8 months. He shares the expenses with his brother. My understanding is his brother is going to be the one that helps post his monetary bond. We're going to be requesting somewhere in the neighborhood of $5,000 on each count, so we're going to be requesting a total of $10,000 bond on Mr. Torres' behalf, Judge.
Your Honor, I would just note, based on the allegations, I don't know that the court can have confidence just based on Mr. Torres' mere representation that he doesn't have enough money to cover the recommended bond amount. Reviewing the probable cause affidavit a little bit more, I would actually also be requesting a nebia and full collateralization requirement.
Okay, based on the probable cause affidavit that I have before me, it is alleged that Mr. Torres defrauded the alleged victim out of a total of, looks like $177,143. There's from the alleged victim's personal account, $17,000 from his bank account, then from his annuity, from his life insurance policy, another life insurance policy, $64,000, $22,000, $23,000, $10,000. Some other charges made on credit cards, an amount of over $20,000. Based on these allegations, I find that the reasonable bond at this time is $50,000 on each count, and no victim contact. And that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Torres?
Yes, ma'am.
Okay. All right. Kimani Clark.
Mr. Clark, come on up, please. He's approaching Judge Sherman. And Judge, whenever the court's ready, we're ready to proceed on Mr. What was your last name, sir? Mejia. Mr. Mejia.
All right. Kimani Clark is before the court this morning. Charge 1, fleeing with disregard to safety, causing injury or death. Number 2, and number 3 are the same thing, fleeing with disregard for safety, causing injury or death. Number 4, possession of a weapon or ammo by a convicted Florida felon. Number 5 is the same charge, possession of weapon or ammo by a convicted Florida felon. Number 6, grand theft auto. 7 and 8, a resisting officer without violence. Number 9, operating without a valid driver's license. Number 10, disobeying or avoiding a red light. 11, unlawful speed. And number 12 is a violation of felony probation. And that probation is with Judge Yuson. I know this case has been reset a few times, so it looks like you're scheduled for a status conference on December 23rd if you haven't already been there. I find probable cause for these charges.
Your Honor, based on the allegations and the fact that Mr. Clark, while committing these offenses, was out on probation for carjacking with a firearm or deadly weapon and robbery with a firearm or deadly weapon, I do believe Mr. Clark presents not only a danger to the community, but I do think he also presents a significant flight risk if he's to be released from custody. I'm going to be requesting $15,000 bonds on counts 1 through 3. Also, there's a concern that he was allegedly in possession of a firearm when the case that he's on probation for involved a firearm. So I'm going to be requesting a $10,000 bond on count 4 and 5. Should he be eligible for release on these new offenses, I would be requesting pretrial release with a GPS monitor level 1.
Judge, I'm fairly certain Mr. Clark, judging from my conversation with him earlier, is not going to be able to afford that monetary amount. My understanding, he's been here his whole life. He went to a job interview. He was actually supposed to start this week at a job working in a warehouse where he was going to get paid $13 an hour. So at this point in time, he really has no sort of savings. He lives in Sunrise with his father. His father is a truck driver. As you stated, he did go to court. My understanding, he went to court yesterday on the VOP. He saw Judge Uson. He was given another court date, but certainly he's being held no bond. So no matter what happens, he's going to still have to seek or go in front of his division judge to seek some sort of relief in order to get released. But Judge, I'm also going to be asking for a photo order and a reasonable bond for Mr. Clark.
All right, I'll sign the photo order, and this court finds that a reasonable bond on charges 1, 2, 3, $15,000, 4 and 5, $10,000. And if Mr. Clark posts his bond, he will be on a level 1 pretrial supervision. All the other bonds will remain in place. Okay. Matthew Flash.
He's a professional.
All right, so Mr. Flash, this is a change of charge?
Yes, Your Honor,
Did
it
we
is. It's
already-
a technicality. When, Your Honor, when he was arrested, the charge was murder, dangerous, depraved without premeditation. You crossed that out in your findings, found proof evident presumption grade for attempted murder, first degree.
Okay.
And that is what he has been charged with.
All right, so it was proof evident presumption grade, no bond.
Findings, just because he's here for what you found, there's no reason to change it.
All right. So we will leave, it looks like we already found attempted murder. This is for clarification, I guess, on the paperwork. So the previous findings will remain. Okay? Mr. Plant, go walk out. Okay.
Yes, Judge, she was here. She just stepped out for a moment.
Oh, and Mr. Plant, the Spanish interpreter and the, who needed the Spanish interpreter? in the
On
meeting?
page 12, Your Honor, it is Mr.
Yeah.
Gerlin Arana Garcia.
He's
No,
approaching, Judge.
we'll have to recall him. The Spanish interpreter walked out for a minute, but
Toma asiento. Ahorita está salido en jefe. Ahorita voy.
what is it? Is it Santa Marina Martinez?
No, Spanish interpreter was Mr. Jerlin Arana Garcia. Judge.
Garcia.
At Maine, on page 12.
Oh, okay, hold on. Okay.
There's also someone in Paul Ryan who requires the Spanish interpreter.
What was that? Do we know?
On the very last page, Your Honor.
Okay, is that Domingo?
Yes, Your Honor, Domingo.
All right, as soon as the Spanish interpreter comes back, we'll address those persons. All right, on page 8, Gordon Raymond. Did somebody sign in on
Gordon Raymond,
Mr.
come on up,
Gordon
please.
Raymond? Does he have there's an attorney, it says attorney, an attorney signed in, no? So,
Oh, so.
All right.
Someone signed in for you.
no,
so.
no, okay,
It's a witness in the case, Hector.
all right. Oh, they signed in where it says attorney, so. All right, Gordon Raymond is before the court this morning on one charge of felony battery. Number 2 is violating a pretrial violation of pretrial release condition regarding a domestic violence. And then number 3 is a court order. It looks like yesterday, Mr. Gordon Raymond was taken into custody by Judge Allspector.
Yes, Your Honor, I believe that was at his scheduled arraignment for
Okay.
the upfile charge.
Okay, so so we just need to set a bond. I find probable cause, and we need to set a bond on charges 1 and 2.
Yes, Your Honor.
Okay.
And, Your Honor, I believe, one moment, Judge.
Right, are we sure he doesn't have an attorney? Because where it says attorney, there's a Andy Newman written there. Who is Andy Newman?
He's the assistant state attorney on the case.
No, that's okay. Okay. I just wanted to make sure. I saw, yeah, I have the copy of the order, yes.
This is Ms. Schauder, she's present, and I suspect the only attorney she's had contact with is Mr. Newman, so I think that's what she.
Okay. Okay,
But I believe she wishes to address the court also.
all right. So ma'am, if you are the alleged victim in this case, is that correct? All right, so and you wish to speak on the record?
Yes.
Then I'm going to put you under oath, and I'm going to ask you to raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down, and if you can speak a little bit louder or speak in the microphone so it can be clear, and I'm going to ask you to state your name for the record.
Rachel Shaver.
Okay? What is it that you wish to say, Ms. Shaver?
This is the second incident. He has threatened to kill one of my friend's brothers. He's contacted me from an unknown number over 200 times. He threatened to send my nude photos to my family and other people that I have known. And I guess that's it.
State.
Your Honor, just to advise the court, and I reviewed the information from the upfiled case, and it would appear he does have a previous battery conviction out of St. Lucie County. It's a 2016 case. As you can see, since both cases involve the alleged victim, this is an ongoing pattern of violence against this individual who I think it is clear has safety concerns. I have safety concerns for her, but the community as well, considering that he is not just threatening her, but individuals that are known to her. I'm going to be requesting a $10,000 bond on count 1, a $10,000 bond on count 2. I'm going to be asking, obviously, for no victim contact and the same pretrial release GPS conditions that Judge Allspector set yesterday.
All right, Mr. Romero?
Judge, I understand what the victim's saying. Obviously, at a later date, we'll determine what are the findings. However, in saying that Mr. Raymond's not going to be able to afford $20,000, as you could see, basically he was taken into custody at the courthouse. He went to court. He's not a flight risk. He's looking forward to contesting these allegations, coming to court each and every time. Now he's 29 years old. He's working. He works at Bahama Breeze. He's a server. He makes approximately about $300 a week. My understanding is he's living separate and apart from the alleged victim. He lives in Lauderdale Lakes with friends where they share expenses, and I believe his portion of the rent is somewhere in the neighborhood, I believe, about $650. We're going to ask the court to consider setting a $5,000 bond on count 1 and a $5,000 bond on count 2. We have no objection, once again, with the no contact order, but we're going to be requesting a total of $10,000 bond on Mr. Raymond's behalf.
I believe the parties were living separate and apart when this new incident occurred because Judge McHugh had already issued a no contact order from his arrest in October against the same alleged victim. So that representation really should not give the court much confidence.
It's before the court for violating a pretrial release condition on the domestic violence matter. And so at this time, I am going to impose $10,000 on each count with the same conditions that was ordered yesterday by Judge Allspector with a level 2 GPS. It looks like this order says they're waiving the fees. No contact with Ms. Shaver, not to come within 1 mile of her home or work. All right, so I'm going to maintain those conditions that were issued yesterday. Okay. Thank you, ma'am. All right.
And Judge, I don't know if
We
I
can-
said this before.
Mejia?
Mr. Mejia.
You can address Mr. Mejia.
Come on up, Mr. Mejia, sorry.
So Jonathan Mejia, this case is on page 24 of the
His mother and
document.
fiancee are present, Your
All
Honor.
right. So Mr. Mejia is before the court this morning on one charge of burglary, occupied dwelling, unarmed, and number 2 is resisting officer without violence. I find probable cause for these charges, and I'll hear from the parties. Sure.
Your Honor, the state would be asking for a $5,000 bond in count 1, along with no victim contact, no return. He was on another's property while they were actually at home. And it doesn't look like he has any prior criminal history, Judge.
Okay. All right, ma'am, I can't see your face. I don't know if you wish to say anything. All right, while she's gathering herself, Mr. Romero, do you wish to speak?
Judge, as you heard from the state, Mr. Mejia has no prior contact with the criminal justice system. He's 21 years old, been here his whole entire life. He's a graduate of Miami Senior High School, class of 2019. He graduated with a 2.8. Unfortunately, he didn't qualify for any sort of scholarships. He's working right now. He works at a smoothie bar where he makes $11.50 an hour. He's saving up to hopefully next year attend FIU. He wants to be a pharmacist. He lives in Liberty City with his mother. My understanding is his 3 sisters. His mom is a single mom, and with his fiance, Judge. My understanding is his mom works. She's a cashier. His girlfriend works at the same smoothie location. They're the ones that are going to be helping to post his monetary bond. Considering his strong ties in my conversation with him, I didn't get any inkling that he's a flight risk. Judge, I'm going to be requesting a $3,000 bond on Mr. Mejia's behalf.
And if I could just add, based on my conversations with the family, I think that's pretty much about the limit of what they might be able to afford, and they would have to enlist the services of a bondsman to do that. And I might just also add, Judge, not to minimize anything, because certainly this is a very serious allegation, but the burglary itself is, from what I can see, running onto this gentleman's property and hiding in his shed when they were caught attempting to break into vehicles.
Obviously, the state took that into consideration. We're making a bond recommendation. If it was inside the actual home, the recommendation would be a lot higher.
I understand that.
All right. Ma'am, are you ready to say something or no? Okay. So, I will impose the $3,000 bond since he has no priors. I am going to order no victim contact and no return to that location at this time. All right. That's,
Thank you, Your Honor.
you're welcome. On, on page 4, Natalie Wilder.
Ms. Wilder is here present, Judge, come on up, ma'am.
All right, Ms. Wilder is before the court this morning. Charge 1, possession with intent to sell new legend drug without a prescription. Number 2, carrying a concealed firearm. Number 3, committing a first-degree felony with a weapon. Number 4, trafficking in heroin, less than 14 grams. Number 5, possession with intent to sell, manufacture, or deliver methamphetamines. Number 6, possession with intent to sell, manufacture, or deliver cocaine. Number 7, driving while license suspended. And then number 8 is a traffic infraction that's not for magistrate. I find probable cause for these charges. And I'll hear from the parties.
Your Honor, just reviewing the probable cause affidavit, I do believe it could be argued that this could be treated as an armed trafficking. That being said, and I don't believe Ms. Wilder has priors, so I'm not going to be seeking a no bond hold. I am going to be requesting, in light of the $75,000 bond on 4, I'm going to be asking for a $10,000 bond on count 3, noting that even without the firearm involved, she faces a 3-year minimum mandatory prison sentence on 4. But as I mentioned earlier, and this will be up to a case filer, it would appear that she was in possession of a firearm while also in possession of a trafficking amount of drugs.
All right, good morning, folks. Is there something any of you wish to say?
Well, based on what the state attorney just said, from what I understand, he, I don't know what to say, ma'am. I really don't.
Mr. Ramirez, is there something you wish to say?
I do, Judge. As the state confirmed, Ms. Wilder has no prior contact with the criminal justice system. She is a registered voter in our community. She works for the Dade County Court of Clerks. That's what she wanted me to let the court know. She's been there employed for 16 years. My understanding, she appreciates her family being present. It's her mother and her grandmother. My understanding is also her mother is retired from the Clerk of Courts, where she worked there for a number of years, and her grandmother is a retired teacher. So my point is she has very, very strong ties to the community. She will be appearing before a court and appearing to all her court dates. She is not a flight risk. Now, my understanding is that she does live in Miami. Like I said, she's been living there her whole life. What I'm going to specifically be focusing on is on count 4, Judge, of the $75,000 bond. I don't believe Ms. Wilder nor her family in her position post that. I was going to ask the court to consider, because of her lack of any criminal priors, to consider a bond reduction to $25,000. And on count 3, I was going to request that the court would consider a $5,000 bond. And that's what we're requesting for at this time, Judge.
All right, just so, this probable cause affidavit says, Ms. Wilder was stopped because, it was revealed that, after running her tag, that she had a suspended license. Once the vehicle was stopped, she was asked if there were any weapons in the vehicle, and she said yes, but she did not have a concealed weapons license. At that time, a brown handle revolver concealed underneath the driver's seat, which is a .44 Magnum with 6 bullets were in the cylinder. When she was removed, there were multiple empty dime bags and a black digital scale. The brown substance field tested positive for heroin, 9.5 grams. The white substance tested positive for methamphetamine. The white powdery substance tested positive for cocaine. Multiple pill bottles were inside her purse. There were 36 small white pills. Those were identified as some prescription-only medication drug. And there were some other orange pills also identified as prescription-only medication. And there were some other 6 other pills that were another prescription-only medication drug. So, in reviewing all of this, I do find probable cause. I am going to impose a $10,000 bond on charge number 3. I will reduce the bond on number 4 to $25,000. Will remain in place. No possession of any weapons or firearms during the pendency of this case. And if Ms. Wilder has any other firearms that has not been, she needs to surrender them prior to being released.
Thank you, Your Honor.
All right, who needed the Spanish interpreter? I have them.
Page 12, Senor Arana Garcia.
Arana Garcia.
He's approaching, Judge.
Madam Interpreter, if you'll raise your right hand, do you swear affirm to interpret from Spanish to English and English to Spanish?
I do. Good morning, Your Honor. Solange Sands, Saenz.
Thank you, Ms. Science.
You're welcome.
Mr. Jerlin Arana Garcia
Señor Gerlin Arana García
is before the court this morning
ha comparecido en corte hoy.
on one charge of disorderly conduct,
Es por un cargo de alteración del orden público.
and I find probable cause.
Decido que existe motivo fundado.
Judge, nothing to add at this time. I'm going to be contacting Mr. Arana Garcia's wife to post monetary bond.
De parte de la defensa no vamos a presentar argumentos, solo le indicamos que vamos a llamar a la esposa del señor Arana García para para pedirle que pague la fianza.
Mr. Garcia, have any priors?
Antecedentes.
It does not look like he has any in Broward, Judge. He has no priors, Your Honor.
De parte del Estado nada en Broward, de verdad nada, no encuentran ningún antecedente.
All right, just based on these allegations, I have concerns.
Basado en las alegaciones de parte de la señoría, tengo preocupaciones.
This was not just one time that he went to this home and was told not to be there.
Porque no fue la única vez que ha ido a esa casa y se le ha pedido que no vuelva o que no esté en esa casa.
All right, and so I am going to increase this bond to $500.
Vamos a subir la fianza a $500.
No victim contact.
Le queda prohibido tener contacto con la víctima.
Sir, that means no phone calls, no text messages, no social media, no third-party contact.
Señor, que le quede claro, eso quiere decir que no puede comunicarse por teléfono, no puede mandar mensajes de teléfono, no puede comunicarse por medios sociales, no puede usar terceros para comunicarse con la persona.
And no return to this location.
Le queda prohibido regresar a ese lugar.
I am ordering a 500 feet stay away.
Debe mantener una distancia de por lo menos 500 pies de esa casa.
All right, the next person, Nicholas Domingo.
Ed Paul Ryan, Your Honor.
All right, for Mr. Domingo, this is a change of charge.
Para el señor Domingo están cambiando los cargos.
For, to abuse of child without great bodily harm, or child abuse.
Han cambiado la acusación a abuso de una criatura sin causar graves lesiones corporales.
Your Honor,
Yes.
at first appearance, bond was set at $2,500.
De parte del Estado, señoría, cuando estuvo con el juez de primera instancia, se le dio una fianza de $2,500.
Just so the court's aware, Judge Rothschild found probable cause for child abuse.
Oh,
Para que tengan cuenta
okay.
la señoría, el juez Rothschild decidió que existía motivo fundado para acusarlo de abuso de una criatura.
He ordered no victim contact
Le prohibió tener contacto con la víctima
and no alcohol.
y le también prohibió consumir bebidas alcohólicas.
Stated,
2,500?
yes, ma'am.
¿Cuánto? 2,500.
Yes.
All right, so I will, this is just, for clarification on the paperwork.
Entonces, la comparecencia es solo para aclarar los papeles que tienen que ver con el caso.
So I'll reimpose the previous conditions with a $2,500 bond.
Así que quedan vigentes todas las condiciones previas y también la fianza de $2,500.
Contact order is still in place.
Todavía tiene la orden prohibiéndole tener contacto con la víctima.
What was the other condition?
No alcohol.
No alcohol or intoxicants is also in place.
La otra condición que queda vigente es también que le queda prohibido beber bebidas alcohólicas o algún otro tipo de drogas.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la ayuda del intérprete?
All right, thank you, Ms. Sayens.
Thank you, Your Honor. Have a wonderful day.
You too. All right, Laureen Aceturo.
No problem, Your Honor.
Good morning.
Come on, take your time.
Ms. Sachaturo would like to resolve this matter today, if possible, Your Honor.
Yes?
Okay. Just sit on the X.
All right, Ms. Aceturo is before the court on a trespassing unoccupied structure or conveyance charge. I find probable cause.
What does
Yes.
that mean?
That means you're facing a trespassing charge for being on somebody's property.
Well, Your Honor.
All right, hold on, okay, hold on, let me hear from the state. Yes.
Your Honor, the state does not have an offer. Respectfully, I don't believe Ms. Aceturo can take a plea at this time. We're going to be recommending that this matter be transferred to Judge Lerner Wren's division. Ms. Aceturo had a trespass in 2017. The case was dismissed April 16th of this year on competency grounds. Now, she was arrested a week ago for trespass at a neighboring location. The case was pled out over the weekend, but I don't even know if the judge was advised about the recent dismissal on competency grounds.
Okay,
But without any further evidence, considering the last judicial finding by a mental health judge, was that not only was she incompetent, but it was not restorable, and so the case was dismissed. in good conscience, I can't make an offer.
Yeah, I really didn't have a problem communicating with Ms. Asatura when I spoke with her before court, but in light of what Mr. Lender says, when does Judge Lerner Wren return?
I think it's next week, but what I can also do, Your Honor, if it's acceptable to the court, is I can contact Judge Lerner Wren's judicial assistant. What they've been doing while Judge Lerner Wren has been out has been notifying Dr. Ludwig, who they would request to go to the jail to do an evaluation.
Okay.
That would be acceptable
All
to
right,
me,
so,
Judge.
all right, so I'll sign an order to transfer to Judge Lerner Rent's division, okay? All right, Mr. Plant, you're back? All right, on, page 3, Tiffany Karowicz.
Maine. Oh, she also has a felony.
Oh, shit, oh, okay.
What page are we on, Steve?
3. Tiffany Karowicz.
On page 3.
There she is.
All right, Ms. Karowicz is before the court. Charge 1 is a misdemeanor capias on a municipal ordinance matter. Number 2 is a felony capias for Judge Porth, who signed a no bond capias. So she has court on the 23rd on the misdemeanor matter, and she has to see Judge Porth on the other matter, okay?
Thank you, Judge.
All
We'll see you in
right,
court, ma'am.
and then Winston Mitchell on page 13.
Also Maine.
Mr. Mitchell, come on up, please. Oh, Judge, he bonded.
Oh, he bonded.
He bonded, so
That's
find
it.
probable cause, and
Happy holidays.
that's it.
Happy holidays, Judge.
Same to you, Mr. Plant.
Merry Christmas, Mr. LaPlante.
Chantal Georges. She's,
Good
In the
morning.
North Broward Detention Center. Your
good
Honor.
morning.
She would like to resolve this if possible.
Yeah? All right, Ms. Georges is before the court on a trespassing on occupied structure charge,
25?
and I find probable cause.
I don't know.
Don't say anything. Let the judge talk.
Mr. Reedy, you had a conversation with Ms. Georges?
I did, Your Honor. She gave me the name of 2 friends of hers that could possibly post her $25 bond, but she also expressed a desire to resolve the case this morning if possible.
All right, Mr. Linder?
Just reviewing, she has a pending trespass before Judge Pohl. I was just reviewing to see. if there's-
Before Judge who?
Pohl.
Oh,
Yeah, what happened was, she posted she kept refusing to come to court, so Your Honor kept the bond at $25. She
Oh.
posted that. Yeah, it's been filed. She has an arraignment scheduled for January 6th. I don't see any of her prior one moment. Your Honor, this is between July 8th of this year and October 21st of this year. She's resolved 4 trespasses, and now this is her second pending since then. I suspect, Judge, it would be appropriate for transfer to Judge Lerner Wren, but,
so she has a pending matter before Judge Pohl. She's had how many, 6 or so
between
trespass?
July 8th and October 21st, she's resolved 4.
It appears as though one of those cases, at least, I think the case in front of Judge Pohl, there's an alert in our system as to Miss George's mental health issues that she might suffer from.
Right.
Again, I didn't have any problem communicating with her before court. I know she does want to resolve the case. It
Well,
concerns me that she has other matters pending.
yeah. And that would be the court's concern as well. So I'm not going to take a plea this morning. I don't know if you're asking me to transfer to Judge Lerner Wren, or otherwise I'll just leave the bond in place.
In the abundance of caution, I would not object to the court signing an order transferring the case to Judge Lerner Wren.
And then we'll do the same thing.
I will ask her judicial assistant to notify Dr. Ludwig.
All right, thank you. All right, Taylor Davis.
Come on.
I'm sorry? Yes.
She bonded, Your Honor.
Taylor Davis bonded.
Yes.
Thank you. All right, I find probable cause. And Kelly Burke.
No problem.
Well, Ms. Burke is before the court on charge one is abuse of child without great bodily harm, and number two is operating without a valid driver's license. I find probable cause for these charges.
Judge, I was going to ask the court to consider possibly placing Ms. Burke on pretrial release. She has been a resident of Florida her entire life. She's been living in the same location for the last 2 years with her fiance. Unfortunately, she is not working right now. She's a stay-at-home mom. She indicated to me that her last contact with the criminal justice system was a number of years ago. She has provided me with the name of her fiance, the name of her mother, and she does have a high school diploma, and she also attended City College. She graduated from Weston High School in 2007. So I'd ask the court to take into consideration the possibility of pretrial release. Also, from what Ms. Bork told me, she does live with the year-and-a-half-old child. That's the subject of count one. The child lives with her and her fiance, and if she is not allowed to have contact with the child, she indicated to me that she might not be able to find a place to live. Right now, the child is with her fiance.
Your Honor, first off, I'm not sure why Ms. Bork is telling Mr. Reedy that it's been a number of years since she's had contact with the system. She was before Judge Schiff, May 2nd of this year, and resolved a theft. And I see, I'm looking at Ms. Bork right now, and she's getting an idea that she doesn't know what I'm talking about. This is case number 19513 MM28, May 2nd of this year. She received a withhold and was ordered not to return to Walmart for 1 year by Judge Schiff. What causes even more concern is, Your Honor, based on the allegations in this case, in 2013, she had a DUI, and now she's here before the court alleged to have been under the influence of alcohol to the point where law enforcement became concerned with her 1.5-year-old child in the vehicle. Your Honor, I am going to be requesting that there be no victim contact. I'm going to be communicating with the officers to make sure the Child Protective Services was contacted. I listened to the the concerns Mr. Reedy represented, but frankly, I think the concerns for the child's welfare are greater at this point.
Well, I know that apparently, according to the probable cause affidavit, there was a delay in getting the proper personnel to the scene where Ms. Bork was arrested, and that is why no further charges were filed. But be that as it may, she is not charged with a DUI. That is not before the court at this time. I understand the state's concern, and I also understand Ms. Bork's concern that if she's not able to have contact with her child, that she will not be able to live where she's living now with her fiance.
Well, is her fiance the father of the child? Where's the child? So the child has another parent.
Ms. Bork, is your
She
fiance the
nodded
father of
yes.
that child?
Yes.
All right, so I find probable cause. We're talking about a 1-year-old child in the back of a car, not in any restraints, and then there is suspicion that she's driving under the influence.
May
And I
please
know-
say something?
No, I don't think you should say anything at this point in time, Ms. Bork. Everything you say is being recorded, can be used against you later. I do know, based on my conversation with her, Judge, that she was in the parking lot. She was going to fasten the child in before she started driving.
obviously, Your Honor, the state's concern is not that the child was going to be in a proper seat or not. And whether she was charged with DUI or not, considering the allegation she was under the influence of alcohol and physical control of a vehicle, and that her 1.5 child was present in the vehicle, it's closely related enough to a prior DUI to be concerned.
Right, officer says I responded to McDonald's and immediately observed a white female sitting in the driver's seat of the vehicle with keys in the ignition and the vehicle on, with a child in the back seat unbuckled. Upon conversation with the defendant, I could smell a strong odor of alcohol inside the vehicle, along with the smell from the defendant's breath. The defendant was advised to shut the vehicle off and step out of the vehicle. While talking with the defendant, she spontaneously uttered that she knows she should not be driving with her child in the vehicle. Those are the allegations. I am going to impose a $5,000 bond on charge number 1, and until further order of the court, no victim contact. All right, Yvonne Serrano.
And I'll make those phone calls for you, Kelly.
Thank you.
I believe Ms. Serrano was here yesterday, and she's represented by Jonathan Friedman.
Your Honor, if I may,
She's scheduled today, Your Honor.
they brought her back, if I may.
But we got a phone call from confinement status, said to return her back.
Okay, hold on, Deputy.
Thank you, Your Honor.
Yes.
Your Honor, I spoke with Assistant State Attorney Lainey Bandel. She's the homicide prosecutor who's assigned to the case.
Okay.
Ms. Serrano had her first appearance in front of Judge Coleman yesterday, as well as he initially heard the state's motion for pretrial detention.
Okay.
My understanding
That's
is, and Jonathan Freeman was there also and stipulated at this point in time, that Judge Coleman ordered her to be held no bond on all counts, all 3 counts.
Okay.
And the motion was continued.
Okay.
So I would ask, Your Honor, based on the representation as an officer of the court, to order Ms. Serrano to be held no bond on this count.
All right, so we'll leave that in place, no bond. All right. Thank you, Deputy. Alencia Hamilton, is she with us today?
Yes, Judge, she is. She's at North Broward.
All right, Ms. Hamilton is before the court. Charge 1 is aggravated assault with a deadly weapon without intent to kill. And number 2 is abuse of child without great bodily harm. All right, I find probable cause. I believe the other person involved in this case has already been magistrated. I believe Ms. Hamilton. No, this is Ms. Hamilton.
Be,
McPhee.
Miss McPhee, I think.
It might have been heard yesterday.
No, okay. All right. So I find probable cause. And I'll hear from the parties. And Ms. Hamilton is the person who's pregnant?
Yes, Your Honor. She's 7 months pregnant right now. And I would be asking the court to consider pretrial release. I believe that she and Miss McVie have a relationship with another child. I'm not exactly sure how it works, but apparently they share.
A child?
They were both involved with the same guy.
Oh, okay.
And then that's what led to this incident here. She has been living here all of her life. She's given me the phone number of 2 aunts that I can contact. She says that she can stay with either one of them. As I mentioned, she is 7 months pregnant, and from what she tells me, she has no prior contact with the criminal justice system.
She does and she doesn't. She just might not realize that there's something formal. There is an outstanding issue summons, Your Honor, for Ms. Hamilton, set before Judge Fry.
So before Judge who?
Judge Fry.
Okay.
I would note the allegations occurred in November 16th of this year while she would still have been pregnant. The allegations are for battery, theft, and criminal mischief against the same alleged victim, Your Honor. Your Honor, I would note, and I just checked, you set the total bond for Ms. McPhee at $2,500. I believe something in the same amount would be appropriate considering the totality of the circumstances.
I really don't think Miss Hamilton or her family are going to be able to come up with that kind of a monetary bond, Judge.
The situation that Ms. Hamilton is in, did she post a bond on the other case? What?
Oh, it's an issue summons.
It's an
so,
issue
yeah.
summons, so she hasn't been, okay.
And if I may, Your Honor, just so Ms. Hamilton can be advised, the issue summons is for her to appear before Judge Fry in courtroom number 4 at the North Satellite Courthouse in Deerfield Beach on January 14th, 2020 at 1:30 p.m.
All right, Ms. Hamilton, when are you due?
I'm doing March 6th.
Oh, okay. Well, then, you have time. You just heard that you have a court date on another matter in January. That's, and, that you have to appear in court. The least I can say, ma'am, is that maybe at this time, you're pregnant, you probably need to make some different choices.
Yes, ma'am.
All right?
No charge. When you have a felony and a misdemeanor, you charge.
It looks like she was Miss Hamilton, who was before me, was the one who was driving, and then she was rammed by McPhee, who was before me yesterday. And then, they began fighting. And you're saying the case that Miss Hamilton has pending is also with the Miss McPhee as the, alleged victim?
Yes, I pulled the information. She's the listener.
All right.
You have to contact the child until after the case is over.
I will release you to pretrial supervision, ma'am. And what that means is that the deputy is going to give you the information for the pretrial office. You need to report to the pretrial office no later than Monday morning. Do you understand that?
Yes, ma'am.
If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
I'm also ordering no victim contact, and that means no contact with McPhee, and that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes.
All right. Okay, Altain Jean.
Thank you, Judge. Good luck, Miss Hamilton.
Thank you.
Mr. Jean is before the court for an out-of-state felony hold, and Georgia has placed a no bond hold on you, sir. You will have to appear before the extradition judge in regards to this matter. Okay? Good morning. Christopher Castro Guerra. What is that?
Mr. Castro Guerrero is approaching Judge Uzzier.
This is from when? And it wasn't signed? What's the issue? Mr. Castro Guerra is before the court. Charge 1 is aggravated assault with a deadly weapon. Number 2, touch or strike battery. Number 3, use or display firearm during a felony. Number 4, possession of controlled substance without prescription. And number 5, false imprisonment. I find probable cause for these charges. And I'll hear from the parties.
One moment, Your Honor. Your Honor, based on the totality of the circumstances, I'm going to be requesting a $25,000 bond on count one, $5,000 bond on count two, $5,000 bond on count three, $5,000 bond on count four, no victim contact, pretrial release of the GPS monitor, no firearms, weapons. I would note that Mr. Castro Guerra is currently out on a total bond of $31,000 before Judge McCarthy for trafficking in heroin, possession of cocaine with intent to sell or distribute, possession of drug paraphernalia. He posted bond on August 31st of this year. He also has a prior conviction, 2007, for aggravated assault against a law enforcement officer, aggravated fleeing and eluding, and possession of cocaine. He violated probation and was sentenced to 3 years in Florida State Prison.
Hey, Mr. Romero?
Judge, I understand he's out on case. Mr. Castro was right. He did advise me of that. He went to court. He has his next court date coming up. Now, he's been here his whole life. He's 32 years old. He's working. He's been working at the same company now for about 3 years. It's an air freight company where he's making about $14 an hour. He lives with his father and his younger brother. His father does know he's here. His father's the person that's going to help post his monetary bond. His father and his family were the people that actually posted his bond and almost exhausted all of their financial resources. Judge, at this time, I believe from what the state has recommended, a $40,000 bond, that's something Mr. Castro advised me that his family's not going to be able to afford at this time. What I was going to ask for the court to consider is a $4,000 bond on count one, $1,000 bond on count two, $1,000 bond on count three, and a $1,000 bond on count five. I do understand because the allegations are serious, he's out on a case. We wouldn't be objecting as far as what the state recommended as far as a level 2 pretrial to have him also be supervised besides having a monetary bond. He just wants to be able to be out there. He has 3 children that he wants to spend the holidays with, Judge. So we're asking a reasonable bond on Mr. Castro's behalf, Judge.
All right, based on these allegations, I am going to impose $25,000 bond on 1, $5,000 bond on 2, 3, and 5. And if Mr. Castro posts his bond, he'll be on a level 2 pretrial supervision. No victim contact, and that means no phone calls, no text messages, no social media. There'll be a 500 feet stay away order. No weapons or firearms. And there'll be random drug testing on the pretrial supervision. $25,000 on one, $5,000 on the other ones. All right, Enrico Sol.
North Broward, Your Honor.
Mr. Sol is before the court for one charge of aggravated stalking, dating violence, and I find probable cause.
If I could just have one moment, please.
Sure.
Thank you. Your Honor, the state is going to be requesting a $30,000 bond, pretrial release with a GPS monitor, no victim contact. I'm also going to be asking that the distance in this case be a mile. Mr. Soul has previously been convicted for stalking, aggravated stalking against the same alleged victim. That was a 2013 case where he violated probation. Your Honor, this is a filed case, and I've reviewed some of the supplemental reports, and one thing I think the court should be aware of, according to one of the reports, one of the alleged threats that he made to the victim in this case was he sent a text telling her that he has keys, game over, look out your window, do you see me? I can tell you some of the allegations from the previous aggravated stalking that he was convicted of involve possession of a firearm and ownership of a firearm.
And I would say, Judge, that Mr. Soule is not going to be able to afford that kind of a monetary bond. I would say in his defense, not to minimize anything, but it appears as though a substantial period of time passed between 2013 and the allegations that are before the court this morning. Mr. Soule has been a resident of Florida since 1993. He's been living in the same location since 2008. He lives by himself. He was an engineer. Unfortunately, right now he is unemployed. And as I say, he hasn't had any contact with the victim in the case for approximately 6 years. And will be abiding by any order that this court deems appropriate as far as not having any further contact with her at this time. His monetary situation, unfortunately, is not very good. I'd ask the court for a lowest possible bond, maybe $2,500, with whatever other conditions the court deems appropriate.
Your Honor, I want the court to be aware, in addition to the victim in this case, it would look like in 2013, a different individual, different woman, sought and obtained an injunction, order of protection against Mr. Soule.
Well, the thing I note is that I know that there's an allegation that he has not been in touch with the alleged victim for over 6 years, but then June 24th, 2019, it looks like he starts the contacts again. And there's over 190 text messages in 3 days. He was arrested, and while he's in custody in Palm Beach, he used the secure jail phone service to attempt 19 calls and voicemails to the victim.
And, Your Honor,
Yes.
I would like the court to be aware. He was convicted in Palm Beach County. As you can see, he was brought down here from Palm Beach. I believe he was brought down here from Palm Beach County. He was convicted of misdemeanor stalking, violating an injunction, and harassing telephone calls, I believe in connection to the phone calls that are mentioned in this case. Additionally, theft. Additionally, burglary of a conveyance, criminal mischief, grand theft. 2013, he was convicted of violation of an injunction. 2013, he was convicted of battery on a victim over the age of 65. And Your Honor, without realizing how, that there have been previous convictions for violating injunctions, and now we're here today on a second aggravated stalking, the only thing I would change from my previous recommendation was I would ask that the level of supervision on the GPS monitor be a level 1.
All right, Mr. Soul, I am going to impose a $30,000 bond with a level 1 GPS and no victim contact. You are not to come within a mile of the victim in this case.
Christmas Day,
All right,
bring me around the golf. I expect you
Those are the conditions. Jason Sherman,
Before you go on for cash, I heard you say 25K for the first and then 5 for the other, but for the last one.
No, these are all.
all right, Jason Sherman is before the court, or touch or strike batteries domestic. And number 2 is false imprisonment. I find probable cause for these charges. I'll hear from the parties.
There's a lot for me to go through. Mr. Romero wants to proceed first. I'm fine with it.
Judge, I believe, yes, there is a lot. My understanding is, Mr. Sherman, basically, he was in custody recently. He self-surrendered, and I believe Judge Al Spector went ahead and released him ROR on a domestic situation, Judge. He's 47 years old. He's been here his whole entire life. He is currently working. He works at a restaurant called Augie's Restaurant, where he's been employed there for the past 10 years as a waiter. My understanding, Judge, is Mr. Sherman lives in Boca Raton with his mother. His mother does know he's here. She is on disability. Financially, they're really not going to be able to afford to post any sort of high monetary bond. I believe the incident or the alleged victim hold on, Mr. Sherman is looking forward in disputing these allegations. He's going to court. Judge, I believe these are all related on the case that he's currently out on. So I'm going to be asking the court to consider releasing Mr. Sherman on a $1,500 bond on each count, Judge.
Your Honor. Your Honor, this is the third pending felony battery due to priors that Mr. Sherman has against the same alleged victim. In addition to that, he has a warrant right now out of the state of Colorado, failure to comply with probation, domestic violence conditions. It's a contempt of court order. The warrant was issued January 19th of 2018. Showing sentenced to 18 months probation in the state of Colorado for harassment and child abuse. I don't know what's happened previously before Judge Allspector. All I know is what I advised the court of, and this is now a third separate allegation of Mr. Sherman committing an act of violence against this same woman. Your Honor, I'm requesting a $7,500 bond on each count with an order of no victim contact, pretrial release of the GPS monitor.
Judge, I just wanted to ask, when was the alleged date of incident on these allegations?
Your Honor, I see September 30th, and that's why I didn't say, I'm not trying to suggest he violated any release conditions. That's why what I simply stated is there's three separate allegations, and I think that's concerning enough.
And Judge, my understanding is, as the facts are the facts, these are other allegations concerning the same victim. But my understanding is, since he was informed to have no sort of contact, there's no sort of allegations, as I believe Mr. Lender did state. He's not accused of violating. He is adhering to those conditions, and he's going to court. So that's why I'm asking. I believe it's reasonable, my request as far as the monetary bond.
Right, I'm going to impose $5,000 bond on each count and continue no victim contact. And no victim contact means no phone calls, no text messages, no social media contact, no third-party contact. That's what it means, and it continues to mean that. Do you understand that, Mr. Sherman?
I do, ma'am, yes.
Okay. Santa Marina Martez.
Your Honor, North Broward is requesting Mr. Santa Marina Martinez's case be reset for the afternoon docket.
All right, so we'll reset for the PM. Thank you. And then Scott Ritz Daniel Scott Ritz. All right, Mr. Ritz is before the court for a change of charge. This is now to a battery second or subsequent offense.
Your
So,
Honor,
what was
this
the,
is an upfile. Again, like I mentioned earlier, I'm confident Judge McHugh was advised of his history.
okay?
She set the bond originally at $1,000 with no victim contact. I'd ask that the same bond be in place and a new no contact order. He's being held no bond out of county as well on a VOP.
All right, so I'll set the $1,000 bond. All right? Okay, Corey Teague. Mr. Teague is before the court on a misdemeanor capias, and I find probable cause. Mr. Teague did not show up for a calendar call on December 12th, and so the judge issued that capias, there's a $500 bond. He does have court scheduled for the 23rd.
Judge, in speaking of Mr. Teague, I advise him of his options. At this time, he wanted me to ask the court to consider resolving this matter. He wanted to know if the state had a plea offer for him.
The state's offer would be an adjudication, court costs, time served, and a no return.
He wishes to accept the state's offer, Judge.
All right, Mr. Teague, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Teague, do you understand the offer that has been extended to you to resolve your case today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. T? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, adjudication, time served, and court costs, I'll give you 6 months to pay.
Judge,
Yes,
that's what I was gonna ask for, 6 months.
I'll give you 6 months to pay your court costs.
Thanks, Judge.
All right, folks, we still have a lot to go through. I'm gonna take a brief recess and we'll be back. Okay, Junior Dalencourt.
Mr. Delacorte is approaching, Judge. He's here at Maine.
All right, Mr. Dalencourt is before the court for one charge of trespassing, occupied structure, or conveyance, and I find probable cause.
Judge, in speaking Mr. Delacorte, unfortunately, he's not going to be able to afford to post the standard bond, which is in place $100. He's homeless right now, but he is working.
You work at the place that they trespassed me from.
So he's looking forward to disputing these allegations. So we're asking on Mr. Dalencourt's behalf if the court could consider releasing him ROR. Or in the alternative, if the court's not comfortable with straight ROR, then to pretrial release, Judge.
Yeah, standard pretrial supervision, okay? Mr. Dalencourt, you need to report to the pretrial office by Monday, no later than Monday morning. If you fail to appear, a warrant will be issued for your arrest. Do you understand that?
Judge,
I'm not trying to get on probation. For what? I work there.
All right, Mr. Dalencourt, pretrial supervision, by Monday morning you need to report. If you don't report, a warrant will be issued for your arrest. I don't
That's
care
what
if
I'm
you
saying.
work there, you've been
Judge,
trespassed from there.
Judge, at this time, Mr. Dalencourt is asking me to withdraw my request of pretrial and just leave the bond in place.
No. Timothy Anderson.
Mr. Anderson is in North Broward, Your Honor. He'd like to resolve this matter today if possible.
State's offer would be an adjudication, credit time served, and no return.
Did you hear that, Mr. Anderson?
Yeah, yes, sir, I did.
Adjudication time served, is that what you'd like to do?
Yes, sir, I would.
All right, Mr.
Third petty
Anderson.
theft can be a felony like
Oh.
we talked about, okay?
Yes, sir, I understand. I have no
Okay.
intention of. Yes, sir.
All right, so Mr. Anderson, please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir,
Yes, Your Honor.
you can put your hand down.
Yes, Your Honor.
And do you understand the offer that has been extended to you to resolve your case today?
Yes, Your Honor.
And do you understand that if you get a third petty theft, even if the amount is 50 cents, it can be charged as a felony?
Yes, Your Honor.
All right, and is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter, Mr. Anderson?
No contest, Your Honor.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication, time served. Terrell
Good luck,
Hardy.
Timothy.
Thank you, sir.
Terrell Hardy. Where is Mr. Hardy?
Judge, I apologize. Who did you court call?
Terrell Hardy.
Mr. Hardy, come on up, please. He's approaching, Judge.
All right, Mr. Hardy is before the court on one charge of resisting officer without violence. Number 2 is trespassing, and I find probable cause.
Judge, in speaking Mr. Hardy, who wishes to resolve this matter today?
State's offer for count 1 would be an adjudication court costs, count 2 adjudication court costs, no return.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Hardy, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
Oh, ma'am.
are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Hardy? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to both counts is adjudication and time served. And sir, I'm also ordering a no return to Abco Food Market at 56 Northwest Eller Street in Deerfield Beach. Do you understand that?
Yes, ma'am.
All right. Michael Jackson.
Yes, ma'am.
All right,
Yes, ma'am.
Mr. Jackson, you're before the court for a petty theft charge, and I find probable cause.
Judge, in speaking to Mr. Jackson earlier today, he wishes to resolve the matter. He wanted to see if the state had a plea offer for him.
State's offer would be an adjudication, for cost, credit time served.
All right.
Ma'am, he wishes to accept the state's offer, Judge.
All right, Mr. Jackson, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. And do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that would prevent you from making a decision?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Jackson?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication, time served, and also an order not to return to that Walgreens. Do you understand that, sir?
Yes, ma'am.
All right.
Thank you.
Good luck, sir.
Jeremiah Baker.
Mr. Baker's approaching. Come on up, Mr. Baker.
All right, Mr. Baker is before the court for a petty theft charge, and I find probable cause.
Judge, in speaking to Mr. Baker, he wishes to resolve this matter. He wanted to see if the state had a plea offer for him.
All right.
The adjudication time served, Your Honor.
All right, Mr. Romero, adjudication, time served.
Thank you, Judge. He wishes to accept.
All right, Mr. Baker, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. And Mr. Baker, you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol? Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, Mr. Baker, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. I'm also ordering no return to that Publix at 601 South Andrews Avenue. And also, just to let you know, Mr. Baker, that petty thefts rack up, third one, you're facing a felony. Do you understand that? Okay. Peter Metzler.
Mr. Metzler, come on up, please. Please approach the judge here, ma'am.
Mr. Metzler is before the court on 2 misdemeanor cases. You did not show up for a calendar call, it says, on December 9th. And because of that, you have a total bond of $500, $250 on each count.
And Judge, and speaking Mr. Metzler, he wanted me to ask the court if the court will consider resolving these matters today.
All right, one is a criminal mischief charge. I don't know.
Your Honor, at this time, the state would not have an offer for the criminal mischief. There would be an issue with restitution.
All right, there is possible restitution, and so he has court on the 23rd, so he'll have to appear before his division judge. Okay?
There's no plea offer at this time.
All right, Gablin Phil-Samey.
Come on up, sir.
Mr. Phil,
Phil Same,
Oh, Bill Saint?
he's in medical recess.
still in
Medical
medical
reset, Judge.
reset? Yes. Did we do that? All right, so. Oh, it does have, well, this has, I don't know how many times we've reset this, maybe three? All right, so, I find probable cause. There is a standard bond of $1,000 in, if the parties wish to readdress that. I guess since he's not here, we can do that, but for now, he's got $1,000 bond. Gregory Rowe.
Please approach the judge at me. Mr. Rowe, come on up.
All right, Mr. Rowe is before the court. Charge 1 is aggravated battery causing bodily harm. And number 2, it's a violation of parole for the Department of Corrections. That has a no bond hold. You'll have to appear before Department of Corrections. I find probable cause. And
Judge, we're going to be requesting a photo order so we can photograph the injuries Mr. Rose sustained. He's been here his whole life. He's looking for employment at this time. He lives in Lauderdale Lakes with his mother, where he's been residing at his whole entire life. We're going to be asking for a monetary bond of about $3,500 bond on count 1, Judge.
I'm going to impose a $5,000 bond. All right, on charge 1. Devin Maynor.
Mr. Maynor, come on up, please.
Mr. Maynor is before the court for 2 charges of burglary, unoccupied dwelling, unarmed. And I find probable cause.
Judge, Mr. Maynor advised me, unfortunately, he has no one to call to help post his monetary bond. He is financially indigent. He's not working at this time, but he's been here his whole entire life. He lives with his mother in Miramar, but unfortunately, he's not going to be able to afford any sort of monetary bond.
Your Honor, the state is seeking a $2,000 bond on both counts.
Does Mr. Maynor have priors?
He has a prior theft from 2019 here in Broward. One moment, Judge.
This year, out of date for a theft out of date this year. Trespass out of date this year.
All right, $2,000 bond on each count, no return to that location. Those, okay. Johnny Pugh,
Mr. Pugh refused, Your Honor.
all right, Mr. Pugh refused. All right, we will reset. Russell.
Yes, please, Judge.
Robertson. Russell Robertson.
He's approaching, Judge. He's here, man.
Mr. Robertson is before the court. Charges 1 and 2, burglary, unoccupied conveyance unarmed. Number 3, possess or receive or retain stolen credit or debit cards. And number 4, loitering or prowling. And I find probable cause for these charges.
Judge, I'm going to be requesting on counts 1 and 2, both a third-degree felonies, a $1,000 bond on each. Now, he lives in West Palm Beach with his grandmother. My understanding is grandmother's person is going to help post the monetary bond. She gets Social Security. He's 22 years old. He's been living in South Florida his whole entire life. He's working, but from what he advised me, as far as he does landscaping, business has slowed down quite a lot, so it's far and few between that he gets calls in order to go out and help out with landscaping. When he does get those calls, he only gets about $60 to $80 a day. So that is why we're requesting a $1,000 bond on counts 1 and 2, Judge.
They would be requesting $3,500 per count. I'm showing 2016 burglary of a dwelling, criminal mischief out of Palm Beach. 2016, he went through diversion for loitering or prowling. 2017, unlawful possession of a stolen credit card or debit card. And this year, he just completed diversion in Palm Beach for loitering or prowling in late June. According to the Florida Department of Law Enforcement, he is also, in 2016, he was registered as a gang member.
Right, Mr. Robertson, looks like you need to start making some changes in your life. I find probable cause. I'm going to impose $3,500 bond on charges 1 and 2, and the other bonds will remain in place. Jose Montez. Mr. Montez is before the court. Charges 1 and 2, burglary, unoccupied conveyance, unarmed. Number 3 and 4, petty theft. 5, 6, and 7, burglary, unoccupied conveyance, unarmed. Number 8, 9, and 10, petty thefts. I find probable cause for these charges.
Judge, on every single third-degree felony, the burglary of conveyance, which is specifically counts 1, 2, 5, 6, and 7, I'm going to be requesting a $1,000 bond on Mr. Montez's behalf. He's 30 years old. He's been here his whole entire life. He works. He does DoorDash on his bicycle. He's been doing that for about 8 months now, where he gets paid about $75 a day. He lives in Miami with his girlfriend. They rent. They do not own. And my understanding is it's about $900 a month in total rent. He's going to be reaching out to his girlfriend to help post his monetary bond. She's employed. She works at Wendy's. So as it is, as far as a $1,000 bond each, is still going to be hard, but maybe that's something through the services, using the service of bondman, they may be able to afford. That's why we're requesting that amount.
Honor, the state would be seeking a $2,500 bond on counts 1, 2, 5, 6, and 7, based on the fact that there are multiple allegations of burglaries and they occurred in 2 separate locations.
It's interesting that Mr. Montez tells Mr. Romero that he's doing DoorDash on his bicycle, but he's driving this black Kia Soul from complex to complex, per these allegations. Approximately 15 vehicle burglary with airbag thefts. He was the driver of the vehicle.
Your Honor, the state would also ask for a no return to but for notification.
All right, so I am going to impose $5,000 bonds on 1, 2, 5, 6, 7, and order no return to any of these locations. And then the other standard bonds will remain in place. Pablo Dupre.
He's approaching, Judge.
Mr. Dupre is before the court. Charges 1 and 2, burglary, unoccupied conveyance unarmed. 3 and 4, petty theft. Number 5, resisting officer without violence. Number 6, possession of burglary tools with intent to use. Number 7, out-of-county felony hold that has a no bond hold and is not for magistrate. Number 8, burglary, unoccupied conveyance unarmed. And 9 and 10, also burglary, unoccupied conveyance unarmed. 11, 12, and 13 are petty theft charges, and I find probable cause for all of these charges.
And Judge, we're gonna be requesting a $1,000 bond on counts 1, 2, 8, 9, and 10. He's been here his whole life, he's 26 years old. Right now, he's looking for more stable employment. He does do landscaping on the side. He lives in Miami. I believe his monthly rent's about $750. And the only person that can help post his bond is his girlfriend, who works at T-Mobile customer service. So that's why we're requesting that amount.
All right, Mr. Dupre is the co-arrestee of the gentleman we handled before. I am going to impose the same monetary conditions on the burglary charges. So on 1, 2, and 8, he also will have 9 and 10. He'll have $5,000 bonds on those, and then the other standard bonds will remain in place. Roswell, no return. Roswell Bridger.
He's approaching, Judge, you decline the service of public defender?
No, I had a public defender.
Oh, you?
Yeah, I have a paid, I do, but I also had a public defender. I tried to tell you that, but you wouldn't let me get through. Yeah, and then I had a,
Well, you can't have both.
well, I did. That's a fact. You can see it right there.
Well, you can't have both. It's either you have a private attorney, or the purposes of the attorneys from the public defender's office is if you're financially indigent. So you can't have a public defender and a private attorney. So at this point in time, you need to choose.
Gave him a lot of money.
I believe it's Russell Williams, Judge, he said.
Yeah, Russell Williams.
All right, so well, here's the issue. Mr. Bridger is before the court on a 1 petty theft charge, and then charges 2 through 13 are all capuses on misdemeanor cases. So I find probable cause, and let me see these. There's a DUI case. He did not show up for a jury trial. There is a petty theft case. He did not show up for a jury trial. There is another case with 5, 6 counts that you didn't show up for jury trial. All right, so I'm going to leave the bonds in place at this time, and you have court before your division judge on the 23rd. Charles Tazwell. Mr. Tazwell is before the court for one charge of burglary, occupied dwelling unarmed. Number 2 is interfering with the custody of a minor. And number 3 is touch or strike battery. This court finds probable cause for these charges.
Your Honor.
Yes.
On count 1, I'm going to be requesting a $20,000 bond. On count 2, I understand that the bond schedule set this offense at a $1,000 bond. Upon review of the allegations, Your Honor, and his history, which I will advise the court of in one moment, I do believe $1,000 would be a completely inappropriate bond to be placed on this charge. I'm going to be requesting a $50,000 bond on count 2 and a $5,000 bond on count 3. While I know the court is aware of the allegations, for record purposes, I would note it's alleged Mr. Tazwell forced his way into the mother of his child's home, a child that he is, according to the report, legally terminated his rights, his parental rights to both children. He grabbed a 9-month-old child and fled the home, ultimately abandoning the 9-month-old child on a public bus. Thankfully, the child was not harmed. Your Honor, earlier this year, last year, was arrested for battery, kidnapping, and child neglect. The kidnapping battery was against the same alleged victim. The charge was dropped late September of last year. Mr. Tazwell has been in state prison out of Dade County. 2012, attempted burglary of an occupied dwelling, burglary of a structure. 2011, burglary of an occupied dwelling and grand theft between $10,000 and $20,000. He was sentenced to 2 years in state prison in 2014. In addition to the bond request I've made, I'm also going to be requesting pretrial release GPS monitor level 1, no victim contact, and I believe these are necessary and appropriate to ensure the safety of not only the adult victim in this case, but the 9-month-old child and the other, and both children referenced in this matter. Nothing further, Judge.
Judge, and as well, the recommendation that the state has requested is financially impossible for Mr. Tazwell. He's unemployed, he's looking for work, he's homeless, he is financially indigent.
$20,000 bond on charge number 1, $50,000 bond on 2, $5,000 bond on 3. If Mr. Tazwell posts his bond, he'll be on a level 1 pretrial supervision. No victim contact. That means no phone calls, no text messages, no social media, no third-party contact. I am going to impose a 1-mile stay-away order. That means you cannot come within a mile of the victims in this case.
And, Your Honor, just so there can be no confusion,
Yes.
I imagine the court is referring to Whitney Henry-Nord and then the 2 juvenile children that are referenced to?
That's correct.
Thank you.
Benny Jenkins.
Come on up, Mr. Jenkins.
Mr. Jenkins is before the court on battery, second or subsequent offense. Number 2 is criminal mischief. Number 3 is a misdemeanor capias.
Your Honor, I believe we're just here on count 3.
I was just, and just noticed that order from Judge Alspector. So he was taken into custody yesterday?
Yes. I imagine you have the order there, Your Honor?
Yes. So everything else is, he's been ROR'd to pretrial with the GPS. And so only number 3 is here for, which has a $5,000 bond on a KPS that was issued because he did not show up for a calendar call on October 28th on a driving while license suspended charge.
And Judge, I was gonna ask, since he was ROR'd on the felony matters to pretrial, I was gonna ask if the court would consider on count 3 the traffic criminal offense, if the court would consider an ROR, if not, the ROR to pretrial as well.
The reason I imagine Judge Brown said a $5,000 bond is I'm showing this is the 1, 2, 3, fourth KPS has been issued in this case. He's made requests in the past that Judge Brown graciously granted and withdrew the KPSs,
And he'll see Judge Brown on December 23rd. Tremaine Griffin. Mr. Griffin is before the court. Charge 1 is grand theft auto. Number 2 is violation of felony probation. So you have a no bond hold to see Judge Bober. You'll see Judge Bober on the 23rd. I find probable cause, and you have a $1,000 bond on 1. Michael Ralderez.
He's approaching, Judge.
Mr. Ralderez is before the court on 1 charge of burglary, unoccupied dwelling, unarmed. Number 2 is grand theft auto. Number 3 is resisting officer without violence, and I find probable cause.
Judge, I'm going to be requesting that the court consider releasing Mr. Rodriguez on level 2 pretrial. He's 18 years old. He's been here his whole entire life. He lives in Miami with his grandmother. His grandmother is a housekeeper now. Mr. Rodriguez is not working. My understanding, Judge, he's scheduled to go back to school, North Park High School. It's a program that he's entered into, and it gives him an opportunity to make up credit so that he can eventually get his high school diploma. And I believe he's scheduled to start that the first week in January. But at this time, from what he informed me, no one's going to be able to post his monetary bond. That is why we're asking for level 2 on his behalf, Judge.
The state would be seeking a $3,000 bond on count 1, and for the this was the $3,000 bond was the same bond that was set for his co-arrestee.
Which was set first co-arrestee?
This one here is $3,000, Your Honor.
All right. All right, I am going to grant that $3,000 and on 1 and no return. Henry Johnson.
Mr. Johnson, come on up.
Mr. Johnson is before the court. Charge 1 is dealing in stolen property. Number 2, false owner info for pawn items. And I find probable cause. All right, any? All right, so we'll leave the bonds in place. Terrence Sadler.
Mr. Sadler, come on up, please.
Mr. Sadler is before the court for a grand theft charge, and I find probable cause.
Judge, I'm going to be requesting if the court would consider releasing Mr. Sadler straight ROR, or in the alternative, leave the bond in place. My understanding, this is the first time he's ever been arrested in his life. He's a registered voter. He's 19 years old, been here his whole life. He's working at Dunkin' Donuts. He's been there 8 months, making $8.50. He graduated from Stranahan High School, class of 2019. Right now, he's next year is going to enroll in Broward College, study sports management. He lives in Pompano Beach with his mother. If the state can confirm he has no prior offenses, this is a nonviolent charge, that's why I'm asking for a straight ROR. If not, I'm gonna be contacting his family to post his monetary bond.
All right, the defendant does not look like he has any priors. The state would be fine with a non-monetary release.
All right, so I'll ROR Mr. Sadler. Mr. Sadler, you need to, it is going to be your responsibility to stay in touch with your attorney or to check the clerk's office to see if you have to come back to court. It is also your responsibility to make sure that the clerk's office has a correct mailing address for you. Do you understand all of that?
Yes, ma'am.
So you can't come back and say you never got notice because you have 3 different ways of finding out if you have court, okay?
Yes, ma'am.
Judge, and also, right now, there was
And-
a form that was made up to instruct them when they release ROR.
Oh, yeah.
As far as all the instructions that you just indicated, a contact public defender, go ahead and contact the clerk's office and everything like that and not get rearrested, so I'm giving that to him at this time.
All right, we did that some time ago. I don't know why it's only now that it's reaching, okay. All right. Jamaris McGee.
Come on up, sir.
All right, Mr. McGee is before the court. Charge 1 is attempted felony murder. Number 2 is burglary of a dwelling or structure. And 3 and 4 are court orders from juvenile court. Yes. Yes. Attempted murder in 2nd degree. Okay. All right, so I find probable cause.
The state would be seeking a $150,000 bond on count 1 and would be asking Your Honor to find proof evident presumption grade count 2. And that he would be held no bond and also no victim contact.
In light of the fact that Mr. McGee currently has 2 no-bond juvenile holds, we will defer any argument regarding proof evident presumption grade until such time as Mr. McGee can appear in front of his division judge.
All right, based on the probable cause affidavit and this warrant to arrest that I have reviewed, I find probable cause. I am going to make a further preliminary finding of proof evident presumption great. And as to charge number 2, Mr. McGee will be held no bond. This is without prejudice for him to have a bond hearing before his division judge. As to charge number 1, I impose that $150,000 bond. No victim contact, and no victim contact means no phone messages, no text messages, no social media contact, no third-party contact. Do you understand that, sir?
Yes, ma'am.
Okay. Ralph Dudon. All right, Mr. Dudon is before the court. Charge 1 is burglary, unoccupied conveyance, unarmed. Number 2 is grand theft. Number 3 is driving while license suspended. And I find probable cause.
Judge, I'm gonna be requesting a $2,000 bond on count 1 on Mr. Dudon's behalf. It's been here his whole entire life. He was previously working for a roofing company, unfortunately lost his job and he's currently looking for employment. He lives in Pompano Beach with his family. He's hoping to get in touch with his family to see if they can go ahead and push his monetary bond. But even if he does get a hold of him, the most that they'll be able to afford is about that $2,000. So I'm gonna be also requesting a phone order so he can access his contact numbers to call his family.
All right, I'll sign the phone order. State.
Your Honor, the state would be seeking a $5,000 bond on count 1. He has a number of priors, and if he was to be released, as a condition, have him placed on a GPS monitor. he was released from state prison in July 2019. He has a number of priors. 2017 delivery of cocaine. He was sentenced to 2 years in state prison. 2017 possession of heroin with intent to deliver or sell. He was sent to prison for 2 years. In 2017, another possession of heroin, possession of amphetamine, possession of cocaine. He was sentenced to 2 years state prison for those.
And Judge, based on what the state said and also what my client just advised me, he does have priors, not disputing them, but they're all drug-related, nothing similar to what's before the court.
Your Honor, in 2011, he was sentenced to 13 months for grand theft and uttering a forged instrument.
And the $3,000 bond, charge number 1, and the other standard bonds will remain in place. All right, Paul Laidley,
I've been informed bonded.
Mr. Laidley bonded.
Mr. Mitchell, come on up.
I find probable cause. Derek Mitchell.
Please approach, Judge.
Mr. Mitchell is before the court on one charge of burglary, unoccupied conveyance unarmed. I find probable cause.
Judge, I'm going to be requesting $1,000 bond on his behalf. He's been here his whole life. He works in a mobile car wash. He's been doing that for about 10 years. He lives with his mother in Miami. She is retired, so I know she's going to be able to afford that $1,000. That's why we're asking that amount, Judge.
One moment, Judge.
Okay.
Your Honor, the state would be seeking a $3,000 bond. He has a 2013 grand theft. He has been to his 8 prior felony convictions, and he has been to state prison.
Mr. Mitchell will have a $3,000 bond. Jamal Cooper.
Please approaching, Judge.
Mr. Cooper is before the court for burglary, unoccupied conveyance unarmed. I find probable cause.
Judge, I'm going to be requesting $1,000 bond on Mr. Cooper's behalf. He's 30 years old, been here his whole life. Right now, he's not working. He's looking for work. His girlfriend and 3 children. She is working, supporting the whole household. He believes that most she's going to be able to come up with is using service of bonds for $1,000.
One moment, Your Honor. Your Honor, the state would be requesting a $5,000 bond. The court should be aware that Mr. Cooper has 6 prior felony convictions. According to the Florida summary report, he has 49 priors where there's been no disposition reported. I can tell you he's got 2 open felonies out of Dade County right now from this year, one of which is for burglary of a conveyance, grand theft, credit card fraud, and criminal mischief. The other is for, there's 3. Burglary, conveyance, grand theft, criminal mischief. The third case is for fraudulent use or possession of personal identification information, 2 charges.
$5,000 bond. Robert Sissel.
He's approaching, Judge.
Mr. Sissel is before the court on a grand theft charge. I find probable cause.
Judge, Mr. Cicero advised me he's not in a position to post a bond nor anybody else. He's asking to be released on pretrial on this nonviolent offense, Judge.
All right, the allegations are that Mr. Sissel took merchandise totaling $1,633.85 from Home Depot. Power tools. Does Mr. Sissel have priors?
Your Honor, that he does. He has a grand theft from 2019 in Broward County. He has a theft from 2016, and he has another grand theft from 2014.
Mr. Sissel also needs to start making new life changes. He has a $1,000 bond. Travis Whitehead. Mr. Whitehead is before the court.
Hold on.
Just hold on. Your bond has been posted. You are here for a driving while license suspended charge, and I find probable cause. And your bond has been posted. Sharif Robinson. Mr. Robinson is before the court. Charge 1 is possession of cocaine. Number 2, false ID given to law enforcement. Number 3 is a civil writ with a purge amount of $350. That's not for magistrate. I find probable cause. And you have a $1,000 bond.
Yes, Judge. I'm going to
Okay.
contact his friend to post his bond.
Michael Leba.
Mr. Labor bonded, Judge. I'm sorry.
Mr. Leba bonded. I find probable cause. Randall Salgado. Mr. Salgado has a driving while license suspended, says habitual charge. I find probable cause.
Judge, Mr. Legato, his rent was just paid, so right now, he nor anybody else in a position to post his bond, so he's asking if the court would consider releasing him under supervision and pretrial.
Is this only Prior's driving charges? Okay.
It was over 10 years ago.
So RR, Mr. Salgado. Mr. Salgado, I'm sure they'll give you that information as well. You need to make sure you stay in touch with your attorney. Make sure the clerk has the correct address for you so that you'll get your notice to come back to court. All right, Anthony James.
He's approaching, Judge.
I have a very bad toothache. It's hard for me to speak.
All right, Mr. James is before the court for additional charges 2 through 6. They are all petty theft charges for which I find probable cause. And I'll leave the bonds that are in place on each charge.
Judge, Mr. James is asking me to ask the court if the court would consider an ROR on these matters. My understanding, Judge, is he's been in custody for several days. He had a $10,000 bond.
She blown me out.
His wife and his family did everything they could to bond him out, and they were managed to scrape all their funds and come up with the bond amount. Right now, they basically exhausted everything. He's been here his whole life. He works at a farm.
I cleaned her up manure.
All right, here's the thing. If you keep doing the same thing in the same place over and over again. October 12th, Walgreens. Go in, the allegations are, you go in, you take 24 packs of Newport cigarettes, total value of $156, from behind the counter, jumps over the counter, leaves. October 20th, same Walgreens, the same thing, this time 6 packs of Newport. November 2nd, same Walgreens, this time 15 packs of Newport. Same Walgreens, November 21st, this time 20 packs of Newport. Same Walgreens, Monday, November 11th. Yes,
You may recall, you had Mr. James' first appearance on count 1 on Monday.
yes.
It was a strong arm robbery at a Walgreens where
No.
he was trying to stealing
His-
cigarettes, and when the
His bonds will remain in place. And no return to the Walgreens. Jamarl St. Jour.
Is in court, Your Honor.
He's in court?
Yes, ma'am.
Okay.
that's fine.
All right, so we'll reset Mr. St. Jour. Joseph Olaya.
He's also at the county, Your Honor.
All right. Mr. Olaya is before the court. This is a ad charge, which is petty theft. And I find probable cause. And Mr. Olaya, you have a $25 bond on this charge, okay?
Okay.
Leon Thomas,
He's also at the county, Your Honor.
all right. All right, Mr. Thomas, is there an ad charge and a change of charge?
Your Honor,
Because I've got 6 as a felony, well, it says not for
I don't know that the
magistrate.
change of charge has
It's
to be
not for-
addressed because
yeah.
there's a bond attached. I just yeah.
But the possession of drug paraphernalia is the ad charge, and I find probable cause, and he has a $25 bond there. Okay, Robert Walker. Okay, Merry Christmas, Mr. Walker. Mr. Walker, you have an ad charge.
I think this is one of those, Your Honor, where if the court's inclined to add one of the charges on your findings.
The KPS has a burglary,
Yeah, the count that's on your findings is the ad charge.
that's
The
a grand
change of
theft
charge-
using vehicle.
Yes, the change of charge went back to a no bond hold for magistrate.
Okay,
The burglary causing damage. Bond was originally set on that count at $5,000. He's got $18,500 in bonds and all the other counts, so I was just gonna request that bond be kept at $5,000.
all right. Mr. Romero, is there something you wanted to say? I'll leave the bonds in place, $5,000. And
Yeah,
then,
Judge, he's asking if we could change the monetary bond, which was set at $7,500 to $2,500. He's been in custody for 2.5 months.
oh, well, that's charge number 9. No, no, I'm not gonna make any changes today, okay? Roberto Almy, is that he's on medical loan still?
I'll check. I got it.
Still medical loan, thank you. And then Bruce Alvarez,
Conti.
He's also in court.
Mr. Alvarez is in court.
Yes, Your Honor.
All right. And then Jimmy Medina.
Yes, Conti, Your Honor.
All right, Mr. Medina, you are here for an ad charge for the immigration hold. And I reviewed the paperwork from Department of Homeland Security. It is a no bond hold. I find probable cause, and you will have to appear before an immigration judge on this matter, okay?
All right.
All right. And then Richard Dahlia.
He's also at the Conti, Your Honor.
Dalia. And this is for a, is this a change or add? It's a change of charge, which now says leaving the scene of a crash with death. What was the previous situation with Mr. Dahlia?
Your Honor, you previously given a bond of $30,000. So you can keep that bond in place with the pre-trial release, GPS, no alcohol, no intoxicants.
So there's a $30,000 bond? Was-
It was 30,000 plus a GPS monitor, no alcohol or intoxicants. Your Honor, just so the court's aware, he's also being held no bond on a violation of probation for a misdemeanor DUI.
Okay. All right, so Mr., I'm sorry, do you say your last name?
Delia.
Delia. I believe the conditions that were previously in place, even on this change of charge, so you'll still have that $30,000 bond with GPS and no alcohol or intoxicants order, okay? And this is only on that one count. Apparently you have other matters with no bond holds, okay?
Right.
All right, sir. All right, I believe that is it for our morning's docket. Thank you, everyone, and we will reset, we come back at 1 p.m.